Thank you, Mr. Chairman. Yesterday, I attended a memorial ceremony at the Supreme Court for former Justice John Paul Stevens. It was a moving ceremony in honor of a man I respected very much and a great justice. And it brought to mind a line that Justice Stevens wrote in his famous dissent in the Bush versus Gore case. Let me read it. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to that confidence that will be inflicted by today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It's the nation's confidence in the judge as an impartial guardian of the rule of law. I think of this quote again today as millions of Americans wake up to the realization that a constitutional right that has been guaranteed for half a century, that they may have known their whole lives and assumed was, quote, settled law, is suddenly on the verge of being extinguished. I don't condone the leaking of internal Supreme Court documents. Senator Kennedy's correct. It is unprecedented. I don't know who leaked the opinion or why. But I know that today, women and men across this country are grappling with the very real concern and, yes, the fear that they may lose a critical constitutional right in just a matter of weeks. If true, this draft opinion that circulated last night would end a half-century guarantee that reproductive rights are protected by our Constitution. Everyone, no matter where you live or how much money you make, deserves access to health care without barriers or political roadblocks. Regardless of the Supreme Court's final decision this summer, Congress cannot sit idly by, nor can this committee. We must enshrine into law a woman's right to make her own health care choices. Long before last night's news, this hearing had already been scheduled to discuss the issues of judicial ethics and transparency. They are important topics, and I welcome the distinguished panel of witnesses here today. I do not take anything near a hands-off attitude toward that branch of government known as the judiciary. As a matter of fact, we just completed an advise and consent procedure for a nominee to the highest court of the land. We do that for judicial nominees at the federal level. We actually determine how many of those judges will be sitting on circuit benches and district court benches. We have the power, though it's been a long time since it's been actively debated or discussed, to even change the composition of the courts. We have many authorities, including the power of the purse when it comes to dealing with the judiciary. So I don't take a hands-off attitude. While we're on the subject, I think we should consider the ethical implications of Supreme Court nominees repeatedly coming before this committee and testifying under oath that they will respect precedent and then doing exactly the opposite when they're confirmed. We must work to ensure, as Justice Stevens said, the true backbone of the rule of law, the confidence in the men and women who administer it. I believe that confidence has been shaken, and we must face that alarming reality. Stronger ethics rules will increase public confidence in the courts and will add legitimacy to their rulings. This will in turn increase public confidence in our democracy. This is not about any particular judge or justice. It's about our federal judicial branch. When we argue the judiciary needs stronger ethics rules, that doesn't mean that federal judges are behaving unethically on any widespread basis. But the Supreme Court itself has recognized that laws governing judicial ethics are not just about regulating actual ethical lapses. They are about avoiding the appearance of impartiality. In recent years, there have been numerous bills in Congress taking a variety of approaches to strengthen judiciary ethics. Just last week, the House passed the Courthouse Ethics and Transparency Bill, which had passed the Senate in February. This bill, led by Senators Cornyn and Coons, increases the reporting requirements in judges' financial disclosure forms and makes those forms more accessible to the public. Hope we can find a path forward for more bipartisan action. I want to thank this panel of witnesses again. I look forward to hearing from you. Thank you, Mr. Chairman.